Good morning, everybody. Happy Saturday. Today is Saturday, March 21st, 2020. I hope everybody's doing okay out there. Strange times we're in right now. Today, first, I just want to let you know that we are open of sorts. We are not having any office meetings or meeting with any clients at this time. We're trying to stay home as much as possible. Nobody really comes into our office. Actually, we haven't seen anybody in our office for the last, I guess, maybe week. We're constantly sterilizing the office. There's just a couple of us in here, but we are going to start working probably from home in the next week as much as possible. I'm already doing that, and we're doing video conferencing with our clients right now. So if you need to talk to us, we'll either reach out to you by phone or by video. We use it's powered by Zoom, so I'm sure y'all have heard of Zoom meetings, and that's what we're using. And so we're still able to conduct business. The courthouse, as probably most of you have heard, all hearings are basically continued for the next 30 to 45 days, and it just kind of depends on where they can fit us in. So if you're one of our clients and we had a hearing scheduled this week or the next week, it's more than likely, well, it has been rescheduled for sometime in the future. And the courts are slowly reaching out to us. Just one of the probate courts in Oklahoma County had something like 390 or over 400 cases, individual probate cases that they had to reschedule. So you can imagine the headache that is. I have had to go to the courthouse a couple times this past week, and they are really doing their best to keep everybody safe. It's a different, strange place there now. And like I said, the judges are not hearing anything unless it's an emergency, is my understanding. We did have one emergency hearing. I did not go to it. One of our other attorneys, Richard Mildred, in our office, went to that hearing, and so that's how they did it. So just emergency hearings from what we understand right now. And obviously, if you're one of our clients, we'll keep you updated. If you're not one of our clients and you have something pending, then I would urge you to probably contact your attorney as soon as possible and find out what's going on with your case. And we are doing the same, reaching out to our clients and letting them know that probably we're not going to have a hearing. So not probably, we won't for the rest of this month anyway. So we'll keep you advised. Today, what I thought we could talk about, though, is something that comes up a lot, and we're always talking about how to fund your revocable living trust, and I'm always telling you that's the most important thing that you can do is if we do all the work to create this revocable living trust package for you, and you've seen the binder that we give you. It's a huge, thick binder. That's a lot of work on our part, and it's a lot of work on your part, because as part of that process, we ask you a lot of questions, and you know it if you've been through this process. And again, probably more relevant today than ever is, you know, that when you come into our office and we have that conversation of setting up a revocable living trust for you, probably the biggest area that we concentrate on, and the area that people are most surprised about when they come into our office and we sit down and have that first conversation, is what do you want to happen if you were to become incapacitated? That is hugely important part of your plan. Everybody always thinks, and I've said this in other videos and other live streams and our podcasts, that everybody always thinks about estate planning is what happens after you pass away, right? And while that is true, nowadays, also, one of the biggest parts that I want you to concentrate on is what do you want to happen to you right now, this day, tomorrow? What do you want to happen while you're still alive? And that has everything to do with, you know, if you become incapacitated, do you want to stay in your home as much as possible? Do you want to go to an assisted living or, you know, some type of residence where there's nurses that can take care of you? A little scary right now, but, you know, that's an option out there. What do you want to happen? And when you come into our office, we're going to go through that, and we're going to try to come up with a plan for what you want to happen right now in your life. Okay, so one of the things we always constantly talk about is funding. So if you go through that whole process, you want to make sure that you have properly funded your trust, right? Because what we do, it's not going to do you any good if we go through this whole process of setting up your revocable trust and you don't properly fund your trust. So real quickly, what is funding your trust? And we've covered this in other videos, which you can check out on our YouTube page. Not right now. Stay on the live stream. We like having you here. But what you can do is check out some of those other videos on funding your revocable living trust. And we've already talked about bank accounts. We have a video on bank accounts and cash accounts. We have a video on real estate, what to do with insurance in real estate. You know, how do you title that into the name of the trust? We have a video, I believe, on mineral interest as well. How do you fund your mineral interest? We also have a video talking about cars. And if you've heard me, I'll just real quickly say you probably don't want to put your car into the name of the trust unless, make sure my glasses are straight here, unless that car is, whoa, that made it even worse. There. Does that look better, guys? You don't want to put your car into the trust unless it is, you know, some kind of a classic car. And then at that point, I would really consider it an asset. And I've talked about that in that particular video, so you can go and look at it. But basically, as you know, a car is a diminishing asset. As soon as you drive it off of the car lot, it is worth less money. And so, and then when you get in a car accident, if somebody sees that you have a trust, automatically they think, ooh, that's a trust. They must have millions and millions of dollars. And so where something may have been easily settled just between the insurance companies, all of a sudden, because a trust is involved, in their mind, they think that this is going to be a big case, and it blows everything out of proportion. So anyway, I've said more than I wanted to on that. But anyway, trust funding is crucial, absolutely crucial to having a revocable living trust-centered estate plan. So one of the things that I really have not talked about in any of the videos specifically is, what about money that is owed to you and business interests that you might have? Also, very important, assets that you have, right? If you were to go out and give maybe a sibling or a child or even a best friend or whoever it is, you loan somebody money, and let's say you lend them, you don't owe them, you lend them. Let's say you lend somebody $50,000. That's a lot of money. And so for whatever reason you lent that money, you have made a substantial investment. You have lent somebody money, and hopefully you've set it up so that you're making a little bit money back. Mostly kind of where we see this, guys, is when people sell their homes, and they might sell their home to a family member or to a friend, and they finance the house for that family member or friend, and so they carry the note. Okay, so that's one way we see this, is somebody will finance a house. They'll basically carry the mortgage on the property. Another way is, let's just say a friend hit hard times, like kind of where we are right now, where somebody may be out of a job and may need a little bit of money. So let's say you lend them $5,000, $10,000 just to get by for the next few months. After everything hopefully is better, then they need to start paying you back, right? So your estate is owed $10,000, $5,000, $50,000 from whoever you lent that money to, right? And so hopefully before you lent that money, you had them, I would hope, you set up some type of document where they actually signed and said that they owed you the money, so that you have a piece of paper that says, I am giving you this money. In exchange, you are going to make payments to me for X amount of money, okay? If you need help with that, give us a call. Obviously, we can help you with that. But make sure you have some type of written document, a legal written document, where it specifically states that that you're lending money to somebody and they are borrowing the money and they are going to pay that money back to you. So make sure you have that document. And if you do have that document and you also have a revocable living trust, one of the things you want to make certain that you do, which is why we're talking about this, right, is you want to make certain that that note, that money that is owed to you by somebody else, is actually titled in the name of your trust, okay? Why would we want to do that? Here's the deal. Let's say it's $50,000, okay? So somebody owes you $50,000 for whatever reason. You lent it. You properly did a note. You have everything. You did everything correct. They signed it. Everybody's in agreement. They owe you $50,000, okay? Now, if that note is not in the name of your trust, then it is still part of your probate estate, which means we are going to have to use your pour-over will to probate that $50,000 note and get it put into your trust so that it is distributed according to the terms of your trust. Does that make sense? Did I make it clear as mud? So basically what we want to do to solve this problem is, let's say you lent somebody money, you lent them the $50,000, you come to us or another estate planning attorney and we set up a revocable living trust for you. Now, you let us know as part of our interview process and part of the whole conversation, the several conversations that we're going to have to set up a properly written revocable living trust. Somebody's calling. So what we're going to do is we are going to set up an assignment. So we're going to assign that note from the person owing it to you to that person owing it to the trust. Okay, so the person that actually owes you the money really doesn't have to even get involved. It's just an assignment that we're doing. We're assigning that note from it's currently being paid to you to owned by your trust. That way, if you were to pass away and they still have not paid off that note completely, then that note will belong to the trust, and they will continue to pay that money into the trust even after you pass away. Also, if you were to become incapacitated, you'll want that money to continue to be paid into your trust so that whoever is your successor trustee, while you're still alive, can use that money to take care of you. So, you know, if it's $50,000 and they're paying on the note of let's just say $700 a month, that's $700 a month that could be used to help you. Now, if it's not in your trust and it's just part of your estate, then we may have to use either a power of attorney or go to a guardianship proceeding just to be able to use that money to take care of you. So very important that if people owe you money, that we put that money, we transfer it to the name of your trust. Next, partnership interests and business interests. So that's another thing that we see come up a lot is people own their own businesses. And when they own their own businesses, what we have to do is look at, especially if they own it with somebody else, it's a partnership, right? We have to look at the partnership agreement and figure out what that partnership agreement says for allowing transfers. Very important language. There are a lot of LLC operating agreements and partnership agreements out there that have very specific language that says that if you were to transfer your interest, so let's say that you are in partnership with Jim, or let's say it's Jim and Enrique. Jim and Enrique have a business and they're partners. And in their operating agreement, it specifically says that if one of them transfers their interest, they have to first allow the other partner first right to purchase that interest. Or they may specifically have language in there that says you may not make any kind of transfer of your interest to anyone, period, without agreement of all the partners. And that may be difficult. If it's just Jim, he may say, that's no problem, Enrique. Go ahead and transfer it to your revocable living trust. But if you are part of a partnership that might have 20, 30 partners in there, it may be very difficult to get the agreement of all of them to allow you to transfer your interest into the name of the trust. So it's very important that you look at that language on what it specifically says, allowing you or not allowing you to transfer your partnership interest into the name of your trust. And it's not that the language is in there specifically for transferring into your trust. It's a lot of times the partnership has language in there to protect the other partners from one of them selling it to somebody that they don't want to be in business with, right? That makes sense. But the reality or the end result of that is that it can put a constraint on transferring your interest even into your revocable living trust. So we always want to look and make sure that if we are going to transfer, we need to absolutely make certain that your partnership agreement allows for that to be transferred. Okay. The next thing is corporate business and professional interests. Kind of the same thing here. You need to look at exactly how your shares are. So if it's a corporation, how are your shares held? Are they in your name? Will the corporation reissue them in the name of your trust? Again, you just need to go look at your corporate structure and talk to whoever is in charge of kind of maintaining the shares in your company and ask them what needs to be done. If your business is a limited liability company, again, kind of the same thing, an LLC, we need to look at your operating agreement to see exactly how we can transfer those shares into the name, from your name into the name of the trust. Now, if it's just you, if you're a sole proprietorship and it's just you, like the Cortes Law Firm, we have an LLC. I own 100% of our LLC. So when I did my revocable living trust, I literally just did a transfer of my interest in my shares to my revocable living trust. Make sense? So you just need to look at your operating agreement. If my law firm was owned by, again, for like a big law firm, which we had 100, 150, 200 partners, that would be different. And I would have to look at our operating agreement and our structure to see how I could affect that change, to change the title of my share from my name to the name of the trust. But anyway, very important that you look at that. And again, if it's just a sole proprietorship, then we simply do an assignment transferring your interest from your name into the name of the trust. So pretty simple to do, but very important to do, because if you don't do these things, then we end up with assets that are not in your trust. And what does that mean when it's not in your trust? It means that those assets need to be probated. So the whole reason you set up a revocable living trust is because you did not, or one of the reasons, I'm sure, is because you didn't want your family or your assets to have to go through probate. And so a lot of times these business interests or these notes, mortgages, that money that is owed to you are some of your biggest assets. And so you have to absolutely make certain that you have them titled correctly. Again, it does you no good to spend thousands of dollars to set up a revocable living trust-centered estate plan done by us or another estate planning attorney, and then you don't properly fund your trust, right? So very important, look at your business interests if you have them. If you're going to set up a new business, we have a lot of our estate planning clients who already have revocable trusts will come to us, and we actually do set up businesses for people. We set up LLCs and partnerships. We do that as part of, I just kind of consider it as part of your overall estate plan, is to make certain that we have proper, well-drafted operating agreements for whatever business that you're in. So a lot of times we'll have our estate planning clients who have been in a particular industry for years and years, and then they go out on their own, and so they want to start their own company, so they'll come to us and we'll set up an LLC or a partnership for them. And if that's the case, then a lot of times we'll work with their CPA, and we'll almost always make certain that that new company that we're forming is in the name of their revocable living trust, so that from the very beginning they're set up correctly, and there's no question on who the ownership is. And there should be no ownership questions anyway either, if it's an ongoing business already. But it's just another hurdle that you have to go through. So that's all for today. We did get a couple questions. One of them I thought was kind of interesting, and that was from somebody who is, I guess, self-identifies as a millennial, and they are, let's see, looks like they are in their early 20s and don't believe that estate planning is something that's important to them, and why should they even be concerned about that? Well, and I'm trying to figure out how to, sorry, I'm still learning our software, so I don't know how to put their comment up on the screen. But basically, if you're a millennial, here's my answer, because I get this a lot. People will, and I'm going to answer the question, but people will ask me just kind of generally, like, at what age should I start thinking about my estate plan? And my answer is always now. Whatever age you are now, that's when you should start looking and thinking about your estate plan. So for a millennial, now, it doesn't matter how old you are, you need to always be thinking about your estate plan. If you've heard me talk in other videos and live streams, I always say that your estate plan has to constantly evolve with your life. So it doesn't matter if you're 20 years old, 70 years old, 50 years old, whatever age you are, that's the perfect age for you to get an estate plan. It doesn't matter how old you are, you need an estate plan. And it goes back to exactly what, unfortunately, what is going on right now in the world. And what I've said in other videos is people are always surprised at how much time I spend about talking about what they want to happen right now in their lifetime. Not necessarily what they want to happen. We do cover it, but not necessarily what they want to happen when they pass away. We want to spend time on what you want to happen. How do you want to be taken care of? Who do you want to be making those decisions for you? So to answer this self-described millennials question, if you are a millennial, you need to have at least, maybe a revocable living trust is not exactly necessary right now, especially if you don't have a lot of assets, but you might want to have at least a will. But I will say you absolutely want to have a power of attorney, a durable power of attorney in place, which covers your finances and makes absolutely certain that there's somebody to step into your shoes and take care of your finances if something were to happen. And you've heard me talk about this in other videos. If you're a college student or you're in your 20s, you still have bills. If you're not living at home, you still have to pay probably rent, probably not a mortgage. But if you're lucky enough to have a mortgage, that needs to still get paid. You have utilities, electric, gas, water. Those all need to get paid. You probably have a cell phone. That needs to get paid. So there's expenses, credit card bills that still need to get paid. So even if you're a millennial who's just starting out, you still have to have somebody who can step up and make sure that those payments are made to keep you incorporated, right? Because your life is kind of like a corporation. So you need to have somebody that can step in and take care of all of that, the business side of you, if you were to become incapacitated for a little while. And again, that's why it's so important right now, unfortunately, what we're having to go through. And then the other three extremely important documents, and you've heard me talk about this in others, and I actually put out a video this week talking about medical power of attorney. So after this live stream, please go check that out. And I go into more depth there, but you absolutely need to have, even if you're a millennial, you need to have your medical power of attorney, your advance directive, and your HIPAA authorization in place and up to date. Up to date is so crucial, guys. So let me just go through them individually really quick, and I'll say at the end why I think it's so important to have it up to date. First, your medical power of attorney is just like your durable power of attorney, right? So your durable power of attorney took care of all your finances. Your medical power of attorney takes care of all of the medical decisions. So what do you want to happen? Who has authorization to actually talk to the doctors and give the doctors and medical personnel authorization to do procedures on you and for you? So that medical power of attorney is extremely important. Now, if you're married, you probably want it to be your spouse. But even if you name your spouse, you want to have somebody as a backup, because in the unfortunate event that both of you were to get into a car accident and both of you are incapacitated, then who do you want to be kind of the successor medical power of attorney? So very important that you think about who you want to be in that role. Your advance directive, the next document, or also called a living will, you'll hear them called that interchangeably. Advance directive or living will is basically a document that says what you want to happen if you become in a persistent vegetative state. So that simply means that a doctor sees no way for you to come out of a persistent vegetative state. Basically, there's no brain activity whatsoever, and the doctor does not feel that there's any way that that'll ever change again. So if you're in a persistent vegetative state, what do you want to happen? Do you want to continue have the medical personnel to continue to try to keep you alive with big old machines that are hooked up to you? Do you want to continue to get food? Do you want to continue to get water? Do you want to continue to get pain medications? Sometimes people say that they don't want any food or water. All they want is to get the pain medications and to let them pass away peacefully. So that's an important decision that is entirely up to you. And think of what a huge gift that is, taking that off of the shoulders of your loved ones if that were to actually happen. That you say, if I'm in a persistent vegetative state, that's a medical term or a legal term, if I'm in a persistent vegetative state with no possibility of recovery, I only want to receive pain medication so that I can pass away peacefully. That takes that entire burden off of your loved ones, and they look to the document and they can very easily just tell the medical personnel, this is what they want. Please do this. And the medical personnel will want to see the document and hopefully will follow the instructions and allow you to go peacefully. So that's what your advance directive or living will is. The next document is your HIPAA authorization. Now, your HIPAA authorization is a document that simply says who has access to my medical information. So if we have a medical power of attorney, if you come to us, you're going to have one. It will also name that medical power of attorney as having HIPAA authorizations. But there might be other people that you also want to have access to that information. They may not be able to make medical decisions on your behalf, but you may want them to have access to that medical information for whatever reason. Sometimes families will put one person in charge, and I think it really should just be one person, as your medical power of attorney, making all medical decisions, life and death decisions for you on your behalf. But they may also put several other people as authorized to receive your medical information, your HIPAA information, so that it also helps that one person who's in charge of those medical decisions to kind of have a group who can all look at the medical information and give input. One person in charge, but maybe a group who, 2 or 3 people who actually have access to the medical information and can at least give their opinion or help if it's needed for the person who has the medical power of attorney. So I wanted to say, why is this so important right now? For obvious reasons. But what's even more important is that you keep these documents up to date, guys. So even if you have, I've heard people say, oh, I have a medical power of attorney, or I've already done all of that. And then my next question is, when did you do that? Oh, we did it in the 80s when we had our first child, or we did it in the 70s when we had our first child. Well, guys, look back at those documents. Do you even know where they are, first of all? That's a big question, because most of the time they don't. But look for those documents, and once you find them, look to see who you have designated as your financial power, durable power of attorney, financial, medical power of attorney, what language you have in your advance directive. A lot has changed since the 70s and 80s as far as medical procedures go. And who are your authorized HIPAA persons? I'm not even sure HIPAA existed back then. But anyway, you need to look at these documents, because here's what happens. If you did these documents back in the 70s, 80s, or even 90s, or even the 2000s, whoever you named in those vitally important roles, whoever you named, they may not be around anymore. They may have either passed away, or they may not live in your city, or you may not even be friends with them anymore. So it's really, really important that you look at those documents and make certain that they're up to date, and the people that you have named are still willing to act on your behalf. So I'm not saying that just because you got a document done in the 80s that it's no good. What I'm saying is it's no good if the people that you have named as your designees are no longer around, right? If they're not around and the people that you've named are not around, then where do we have to go? We have to go to the courts, and we have to get probably an emergency guardianship proceeding done. So I urge you guys, please, I mean, all the time I would urge this, but especially right now, please go and look at your documents, wherever you have them stored, and find out who you have as your designees. Who do you have as your medical power of attorney? Who do you have as your financial power of attorney? Have you named successors in case they can't do what you're asking them to do? I'll just use myself as an example. I have my sister listed as my successor trustee, and I think I have her in, see, I need to check in those other roles as well. But here's the thing. I'm 51 years old. She's, she would say that she's several years younger than me. But the reality is that as I age, she's not going to stay the same age either, right? She's aging with me. So I would have you look at your plans as well. If you are, if you had your plan done in the 80s or 2000s or whatever it is, and you're in your 60s, 70s, or 80s, look to see who you named back then, because if you did it in the 80s, those people are 30 years older than they were when you actually named them, right? Is that right? 80s, 90s, 2000s, something like that. So look at those documents and make certain that who you have named, first of all, are still around. And if they are still around, do they have the capacity and the willingness to continue to act on your behalf if the time came? So more important than ever right now, please check those designations and make certain that those documents are up to date. So that's all I got today, guys. Please be careful out there. Please continue to wash your hands. Stay at home. There's no need for you to be coming out. Let's all try to be careful and care for one another. You staying home is probably one of the best things you can do for everybody else. So take care of yourselves. We hope you have a great week. And one of the things we thought about doing is maybe doing a daily live cast. We'll see how things go. But if you have any questions, just put it in the comments, and have a great day. Stay safe. As always, have an awesome week. We'll see you next time. Thanks for watching, guys.